So I'm always hearing from conservatives, oh, you're overreacting to the Supreme Court. After all, they're just returning power to the states where it belongs, right? Well, I'm here calling BS. Let's talk about it in today's video. Hi, I'm Mike Greiner. I'm a lifelong Democratic activist who's concerned about the direction our country is taking. I'm also a lawyer and an academic, and I'm here to help you stand up to the BS of the MAGA crowd. So the argument that we hear again and again from the supporters of the Supreme Court is that they're not activists, that their decision overruling the right to abortion is actually a consistent reading with the Constitution, one that goes back to the original documents, and no longer allows the court to substitute its judgment for the judgment of the elected representatives of the people. Does that sound familiar? Every time I do a video on the Supreme Court, I get comments from conservatives stating basically that case. And the problem that they have is that that argument doesn't work when you look at the other case the Supreme Court has decided. Let's take a look at one in particular, and that's Brnovich versus Democratic National Committee. This is a decision that was decided in 2021 with a decision authored by Justice Alito. The facts of the case involve a voting restriction that was passed by Arizona that the Democratic National Committee filed a lawsuit against. In particular, the Democrats argued that Section 2 of the Voting Rights Act banned this type of election meddling that Arizona was engaging in because it made laws that have a discriminatory effect illegal. Specifically, the statute reads that there is no requirement to show discriminatory intent of the legislation. All that has to be shown is an effect of the legislation which, quote, results in a denial or abridgment of the right to vote on account of race or color. In other words, they don't need to show that Arizona intended to stop black voters from voting. All they had to show is that it would make it harder for black voters to vote. That's what the statute said. Now, it's worth noting, by the way, that Congress has amended the Voting Rights Act of 1965 5 times, each time making it clear that, yes, we want to stop discrimination against voters. In some cases, such as in 2006, Congress actually passed legislation to overrule the judgments of the Supreme Court. In that case, overruling Reno v. Bossier Parish School Board of 2000 and Georgia v. Ashcroft of 2003. Again, each time making it clear that the statute is meant to stop discrimination against voters. And yet, repeatedly, the Supreme Court steps in and pushes back and allows the states to discriminate against voters. Ironically, when it was reauthorized and amended in 2006, it was done with the support of Republicans, ultimately signed by President George W. Bush. No liberal by any stretch of the imagination. But here's what really gets outrageous. In this era where the Supreme Court is supposedly returning power to the people's representatives rather than the courts, and in fact, in Brnovich, the court was quite explicit about the fact that, quote, the court's statutory interpretation starts with a careful consideration of the text. So supposedly, they were looking at the text of the legislation passed by Congress to determine how they should rule. Well, ultimately, the court found that despite overwhelming evidence showing that there would be a disparate impact of this legislation that would specifically hurt the voting rights of African Americans in Arizona, the court held that this legislation did not violate the anti-discrimination provisions of the Voting Rights Act. Now, that would be outrageous enough in and of itself, except for the rationalization that the court gave for its opinion. Specifically, Justice Alito wrote that voting rights restrictions passed by the state are acceptable as long as they do not impose more than the, quote, usual burdens of voting that were in effect in 1982, 40 years ago. This is a time when early voting and absentee voting laws were rare across the country, and registering to vote was quite onerous. I mean, I have to tell you, that's the era when I registered to vote first. And it was kind of a hassle. In fact, when I was in college, I remember I used to organize voter registration drives on campus. And it was a big hassle where I had to make arrangements with the local clerk's office so that they could have actual clerks from the town come to campus to do the voter registration. And that was in progressive Democratic Massachusetts. And again, that would be even worse, except for the fact that while Justice Alito is saying that he's supposedly strictly interpreting the language of the statute that was passed by Congress, numerous times, I might add, nowhere in the statute, let me make this clear, nowhere in the statute does it say anything about 1982, or somehow the burden of voting in a certain year being an acceptable level of burden, and anything that doesn't exceed that is okay. In fact, if you think about it, the statute does exactly the opposite of that. Because the whole reason the Voting Rights Act was passed was to make it easier for people to vote. In other words, the statute, which again was reauthorized numerous times by Congress, multiple times specifically saying to the Supreme Court, this is what we intend to do, that statute specifically says we want to make it easier to vote than it is today. So in other words, Alito's opinion, which supposedly is based upon the plain language of the statute, has no reference to any plain language anywhere in the statute, but what's more, goes directly against the exact congressional intent, which was repeatedly stated and made clear again and again when they passed it time and again. So much for interpreting the plain language. So much for returning the power to the people's representatives. In this case, the people's representatives are Congress. And Congress made it clear what they wanted again and again, and Alito, as part of his supposed statutory interpretation, read into the statute something that it says nowhere in the statute. So to those conservatives who are claiming that this Supreme Court is simply returning power back to the people where it belongs, spare me. The fact of the matter is, the other court's opinions make it clear that this is nothing more than a partisan Supreme Court that is doing what it wants, when it wants, no matter what the statute says and no matter what precedent says. This is not a Supreme Court making rulings based on law. This is a Supreme Court making rulings solely on ideology and simply making arguments to fit their ideology, which may conflict with each other in different cases. But it doesn't matter because they don't care. They have the power. Well, if you want to see how outrageous this court has become, just check out this other video over here where I talk about an opinion written by Chief Justice John Roberts, where he was dissenting from the conservative majority, joining liberal Elena Kagan in arguing that the court had gone too far and had become nothing more than a right-wing ideological tool. I'll see you then. In the meantime, let's hope for continued progress. Thank you.